Hi. So today I'm going to share with you about a recent Supreme Court judgment pertaining to a registered gift deed. Now in that case, there was a registered gift deed. There were witnesses. Witnesses also came to court. The person in whose favor the gift deed was executed, that person also came to the court. In spite of all these circumstances, Supreme Court held that the gift deed is valid. Now it's an interesting case because the fundamentals of a gift deed is that it must be registered. Here, the ingredients of the fundamentals of the gift deed as per the Transfer of Property Act were fulfilled. That is to say, it was registered. There were witnesses. The witnesses came to court. The donee, in whose favor the gift was executed, came to court. Even then, court created a principle which I am going to share with you right now. That is to say, the intention of the donor. If there is no intention of the donor in the execution of the gift, even though it may be registered, it is invalid. That is the principle. The gift deed must be voluntary. The intention must be there because it is a transaction out of love and affection. In gift deed, there is no consideration. It is out of love and affection. The gift deed was made in favor of the receiver of the gift, who is called the donee. So the donee has to prove that there was love and affection in his favor, a clear-cut bona fide intention, the gift was voluntary, and there are no adverse intentions, and there is no influence. This is very important. So if these all factors are not proved by the donee or the receiver of the gift, then in spite of registered gift deed, in spite of witnesses who signed before the sub-registrar's office, in spite of the signature matching before the sub-registrar office, the document, even the fingerprints also matching the document, malefits can be attributed to the transaction if there is no intention to give the gift, if there is no love and affection. In this case, the donee or the receiver could not prove all these factors. Having said that, the possession was also not proved. The mutation interests were also not proved. So not only registration of the gift deed, it has to be mutated. So the mutation also plays an important role. The possession also plays an important role. The delivery of possession also plays an important role. Intention plays an important role. Voluntariness plays an important role. Absence of any influence plays an important role. Presence of love and affection plays an important role. Or if all these factors are not proved by the receiver of the gift. So the sum and substance of this video is, in spite of the gift deed being registered by the donor, it will be set aside. The transaction will be set aside by the courts. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.